Companies Act, a special presentation by The Firm.
Chapters 19 and 20 were meant to provide India a modern bankruptcy regime in which sick companies are given some tender, loving care. Okay, maybe not so tender or loving, but at least the chance of revival. And terminally ill companies are allowed to die or wind up in the most efficient manner possible, affording protection to all stakeholders. Does the Companies Act 2013, in its provisions for revival and rehabilitation of sick companies and winding up, fulfill any of these needs? While joining me on this 15th episode of our special series, Alok Dhir, Fereshte Sethna and MR Umarji. To all three of you, a very warm welcome to Companies Act. I'd like to start by focusing this episode on Chapter 19, which is Revival and Rehabilitation of Sick Companies. Chapter 19 makes a radical departure from SICA by providing that any company, not just a manufacturing one, can be determined to be sick if 50% of its secured creditors demand a debt repayment and the company fails to pay the debt within 30 days. And a secured creditor or the company itself or even a public financial institution or a government moves the National Company Law Tribunal. Net worth erosion is no longer the sickness threshold. The applicant may also apply for a stay of up to 120 days on winding up proceedings, execution against any company assets, or apply for the appointment of a receiver, and that no recovery suit shall be proceeded with. Once a sickness application has been filed, the company cannot sell any of its assets or properties, nor can its board take any action detrimental to creditors. The tribunal has 60 days to determine whether the company is sick or not. If found to be sick, the tribunal must decide if it's practicable for the company to repay its debt and accordingly grant the company time to do so. Alok, I think the most important thing is here, the definition of sick has gone through a sea change, right? It was earlier linked to net worth erosion. It no longer is linked to that at all. It's just simply the inability to pay back 50% of your secured creditors. That's a good thing according to you?
According to me, it's a very grey area. There is now, at this point of time, no definition of a sick industrial company at all or a sick company per se at all. What are the factors which will weigh with the tribunal to determine whether a company is sick or not is not clear. The rules do throw some light. The rules provide that while determining the company as sick or otherwise, the draft rules I'm talking about, the question will be, the reason for default will be gone in by the tribunal. Yeah. The second is position of debts owed by the company, not relating to these secured creditors but others also will be there. Those are the only two factors to be considered. Now, when there is no definition of what a sick company would be, how the tribunal is going to determine the sickness, at least I don't know.
Does it give the tribunal flexibility to determine based on the facts at hand whether the company is sick or not?
The width and amplitude is precisely what the new provisions intend to usher in. Right. So that level of discretion, which is clearly vested with the tribunal, I think is a welcome requirement because it allows really for secured creditors to get in while the company is still afloat rather than waiting for net worth erosion. Yeah. So I think it's absolutely a step in the right direction.
And 30 days default is a very clear basis on which the company can be declared.
And so you're trying actually to nip the problem in the bud as opposed to, as Fereshte said, waited for the company's net worth to erode and then try and fix something that's probably unfixable.
The other issue which is very relevant is that this application can be filed by the company itself.
Yeah.
So I am running a business. If I am in a problem, I can always come forward and tell the tribunal that I am not going to be able to comply with the terms of payment. There is going to be a default. So I want a revival scheme to be formulated for me.
So the initiative then is in the hands of the creditors, the company, in some cases public financial institutions, scheduled banks, state governments, depending on their exposure to the company, for them to take the call saying let's move ahead as opposed to waiting for things to get so worse that there is no, there's no way to fix it.
I may just point out that in 2002 when the Companies Amendment Act was framed, they had actually given two guideline factors, there two regulations. Right. One was 50% erosion of net worth, the other was inability to pay debt. Now, there is no such criteria anymore. While I accept that there would be discretion in the hands of the NCLT, but every discretion has to be based on some parameters. And unfortunately, no parameters whatsoever are given. So, determining whether a company is sick is one issue. Knowing that the company is under financial stress is another.
As a matter of fact, the Standing Committee on Finance 2012 did examine precisely this issue, which was flagged off for consideration. And they came to the conclusion that clearly we can live without a definition. So I think to circumscribe is really not necessarily in the best interests of Chapter 19.
Okay. The process so far is, as I've put it quite simply, is there anything else here that's cause for alarm in any fashion? This is up to the tribunal determining within a 60-day period whether this company should be sick or not.
In my view, the 60-day period is too short.
Why? I thought the whole idea was to speed this up.
Yeah, that is true, but the legal process being what it is, if an application is filed by a creditor, certainly an advance notice is required to be given to a company. The company may have its own reasons. It may file its own replies. It is good to have a timeline. But if the timeline is rigid and within the manner of litigation that goes on in the country and in the manner in which we have seen in sick industrial companies with very firm parameters, such a long time being taken in determining whether the company is sick or not, in a situation like this, it will never happen. In 30 days, they can't decide. They won't even have a...
Isn't that the whole purpose, Alok, of setting up national company law tribunals? They're specialized tribunals that will not come with the baggage that our courts do, or that, you know, BIFR or company law boards have suffered all these years.
Yeah, true, but how
and
do you
therefore
do
we'll
this,
be able to
Melika?
move faster.
How do you do this? I mean, if you are going to ask somebody to give a response, application is filed by a creditor saying that I'm sick. In the situation that we now know there are no parameters for determining this, they will come back with some sort of a reply. You need to give them time. There is natural justice. When they come with a reply, the creditor needs to come back with a rejoinder. How are we going to compress all this within 30 days? It's a rigid timeline.
No, according to me, it's a right provision. It conforms to the recent guidelines issued by Reserve Bank on stressed asset management. Okay. There also the time limits are same. That special mention account is after 30 days default. Then special mention account 2 is after 60 days default. Now, this is a time within which you are supposed to work out a scheme.
The point I want to make is this. The fact is that this new provision, 253, specifically imposes upon a secured creditor an immense level of responsibility to take upon itself the onus of actually wanting to shut you down because you have defaulted. You're in potential default. They're watching you closely. Right. To my mind, the point that Alok made with regard to notice, according to me, the very fact that you're on the verge of default is something best known to you in any case. So you better start setting your house in order unless you really want to sort of, you know, face 19.
And really, how long should you wait? Because the longer you wait, the more pointless this entire process gets, right?
194,000 crores NPA. What are we talking about in this country anymore? Public funds need protection.
If a company has been determined sick, a secured creditor can, within 60 days of such determination, apply to the tribunal to recommend revival measures. Unless, of course, secured creditors representing 3/4 of the debt have already recovered assets using SARFAESI. Or, if the assets have been sold to an ARC, then the ARC must consent to such a revival scheme. On receiving a revival application, the tribunal shall call a hearing within 90 days and appoint an interim administrator to determine, in consultation with a committee of creditors, the workability of such a revival scheme. If a revival scheme has not been submitted by the company itself, then the tribunal may direct the interim administrator to take over the company management. Thereafter, based on the vote of creditors representing 3/4 of the company's debt, present and voting at the meeting, the tribunal can either decide to wind up the company or revive it. Does it come anywhere close to Chapter 11 in the US?
Absolutely, because in fact, creditor committees is straight out of there. Creditor committees is a huge step forward, and that is something that is perhaps going to be the turning point if we stack them up right. So that is again going to be critical, because it's really going to be creditors make or break these companies eventually.
And this is the first time in this provision and in this chapter that the representation of unsecured creditors comes in, right? Because the Creditors Committee will cut across all classes of creditors.
And as a matter of fact, the UNCITRAL rules for legislation on insolvency 2005 specifically envisages the significant role that creditor committees can play in the process of an insolvency or potential insolvency.
Right.
So technically, this is something that has been far wide recognized globally, as a matter of fact, not just necessarily in Chapter 11. So it's really the step in the right direction in my mind, and I'm quite sure that we should see the benefits of that as we move forward. But as I was saying to Mr. Umarji just a short while ago, it's about 10 years minimum before we see the benefits of this legislation paying off.
That would happen with any law, right? With any law that's proposing a dramatic change.
That's right.
How do you see this process, Mr. Umarji?
I fully agree with her. It is in conformity with the UNCITRAL recommendations on insolvency.
Right.
And the appointment of an administrator who can be a professional is going to change the entire scene.
Why is it? Because he will bring more integrity to the process, speed to the process?
Speed to the process. And so we are going to have a new category of professionals who are insolvency practitioners.
Which is good, right? Because that's what you need. That's the expertise.
Who are there in other countries, in developed countries, they are operating. So there is going to be a new specialized professional who is expert in insolvency proceedings, actually, and formulating schemes for turning around companies under stress.
I think Creditors Committee is absolutely a step in the right direction.
Okay.
Appointment of insolvency professionals is also a very major move forward. And I think more than anything, they'll bring professionalism into the whole process.
Sure.
The official liquidators of the past were very bureaucratized. The insolvency professionals in all possibility will come from the branches of law and accounting and finance, and will have abilities to prepare quickly schemes, and they will have administrative abilities to manage the affairs of the company in a more meaningful manner, and to be able to conduct the creditors committee meetings and the process of rehabilitation and revival of the company far more swiftly, because now there is a professional entity. Currently under the BIFR you have operating agencies which happen to be usually one of the secured creditors of the company, and unfortunately the task slips from senior officers to junior officers and to even more junior officers, till you end up noticing that only a manager level person is actually conducting the operations of what an operating agency is required to do. I think it's a huge step forward.
You don't think it's too much power in the hands of the interim administrator? Because that's maybe a complaint that promoters could likely have of companies, saying, well, he could even take over the management of our company. That's provided for in this section. I'm not sure if that's a bad thing, because once you've been determined sick, then I'm not sure how much right you have to stake claim or continuous claim over management. But that could be the complaint that comes up.
No, in my view, it is very, very important to take the company out of the hands of the defaulting borrower. What happens is that it will require a great deal of expertise for some interim administrator or a company administrator to step into a company which is live and operating and take over the reins in double quick time as is prescribed is not going to be easy. It is going to require a lot of expertise, a lot of experience, a lot of maturity, and a lot of understanding of the business. But it's something that we have to look forward to. As she very rightly said, 10 years down the line, we'll see the fruits of this coming up. In other jurisdictions in the world, this is happening, and I see no reason why it should not. Having said that, since you compare Chapter 11, let me just point out one or two issues. In Chapter 11, there is a voluntary filing. There is any company who feels that it is under financial distress.
This too allows for a voluntary filing.
It doesn't actually.
It says the company can file.
It can, but it is only subject to the notice under 253(1).
Okay, so you're saying that they should have at least made the provision for a company without having failed to repay its debt to consider making an application.
That would have satisfied me more.
Okay.
Because then the criteria of sickness would not have been so relevant. But since you are not allowing a company to file and secured creditors can move an application, therefore the criteria became necessary in my view.
Okay. Unsecured creditors have a limited role to play so far in the process, and I would think that's right. I can't see any reason for them to complain.
According to me, I think they have a far more say than we are assuming at this stage. Because the stage at which the meeting is to be held, because as soon as 254(1) application is filed, there is a meeting which is required to be held. It says 3/4 of the creditors. It doesn't say secured or unsecured.
That's right. 3/4 of the creditors present and voting at the meeting.
So when you start weighing secured creditor versus unsecured creditor, you would see many situations where unsecured creditors outweigh the secured creditors in terms of volume of debt. So they, in my view, they are having far more say than we are assuming that they would have.
Okay.
We can't proceed beyond that step unless they also agree.
Companies Act, a special presentation by The Firm.
If the creditors vote for a revival, the tribunal shall appoint a company administrator to prepare a scheme of revival within 60 days and allow him to take over management of the company if so required. The revival scheme may provide for financial reconstruction, management change, asset sales, labour cuts, restructuring of debt, etc. The scheme needs the approval of 25% of unsecured lenders and 75% secured lenders and a final nod from the tribunal within 60 days. In order to effectively implement the scheme, the tribunal has considerable powers. For instance, not only can it keep the company administrator in charge, it can modify or cancel any contract of the company. If the revival scheme is not approved of by the requisite number of creditors or it fails during implementation, then the tribunal may order winding up. What I like is that there are clear timelines put in, Alok, but I think you've already expressed that you don't agree that these timelines are adherable, so to speak.
Yeah, I'm very apprehensive of timelines across the board. I think all the timelines, and frankly, let me tell you, if you put all the timelines, put all the ducks in a row, it's 367 to 427 days.
Yeah,
427 days. It's a long time.
But that's a counterproductive argument.
No, let me explain to you.
Okay.
Let me explain to you how it works. Once the report is coming from an administrator, the NCLT has 60 days within which to sanction a scheme. Now, they have to publish the scheme also in the newspapers. That's required in law. They have to hear objections from others. There are vested interests. Creditors are not the only entities which are involved with this. Labor will be involved. There would be other people who have contracts, as you very rightly said. Some contracts can even be set aside. So they will all have a say. How are we going to do it within 60 days?
I don't. So on the one hand, you're saying, look, even if you add up all the defined timelines head to toe, it's 420 days approximately. That in itself is a fairly long period. But then you're saying even that is not enough.
That the reason why I say it is, it was possible for them to compress this whole thing. As I said, there are 3 levels of meetings. There could have been only 2. And sometimes, Minika, timelines, it does take time. If you go to chapter 11, it takes sometimes years for them to get a restructuring scheme.
And sometimes it takes months, just a few months,
it does.
3 or 4 months.
I want to tell you,
that happen in the last 5 years.
Absolutely.
In several instances.
Where the creditors and the defaulting borrowers are in sync with each other, you could actually rush through a scheme under chapter 11 within months. The problem with this enactment is that it's just too rigid.
No, it's not rigid. Yeah. You see, if there is a consensus, you are going to able to
move fast.
Move fast. If there are persons who are obstructing the entire revival scheme, then ultimately it may mean that if the company is unable to convince them and agree to a revival scheme, it will mean end into a winding up of that company. Ultimate analysis. And the other point in this is that there is already a corporate debt restructuring scheme of RBI. Which is non-statutory. It is already operating, but it has some restrictions. It applies to multiple banking.
It leaves out foreign banks, it leaves out unsecured, everything, all of that.
This provision is making a statutory provision for corporate debt restructuring.
So it will replace CDR altogether, you think?
No, I mean it is becoming available to everybody, all the companies. It's not necessary. Only a single bank is the lender, even then it will apply. Whereas CDR is not applicable to single bank cases. So therefore, it is fitting in the similar provisions as in CDR into a statutory provision.
Now, honestly, you know, we've seen the evils of the system where you had endless adjournments, and I think it's time that we actually hack down on that.
Umarji was telling me the average time that it took for a company to wind up in this country, which is the next stage after this,
to be
15 to 20 years.
So,
20 and counting, actually.
I don't know who gains from that, because if you're a creditor, you know, you've lost all that money.
And the assets get deteriorated, and this will result in putting the assets to productive use.
Let me tell you, rehabilitation and revival is not financial restructuring. I think the error we are making is, we are putting down the entire concept of revival and rehabilitation of sick companies as a simple financial restructuring exercise. It is far more than that. But what happens to the workmen? What happens to statutory dues? What happens to various litigations which are going on with respect to sales tax, customs, excise?
Dues, isn't that taken care of in the very first section itself, where they say that the state, you know, if the manufacturing units are in that region, can in itself file the petition for sickness.
But where is the process? There is a secured creditor, there is a sales tax due in a certain state which has a priority over a secured creditor. How are you going to revive this company?
The stage at which this is getting done is 30 days default.
Right.
And the entire scheme will have to take care of all the liabilities of the company.
It's wishful thinking, my friend. I mean, how do you deal with a sales tax
this is what the company has to provide for.
What do you think?
And as far as the if there is a winding up, that's another important issue which has to be borne in mind. If there is a winding up, the sales tax dues or the other dues of the government do not have a priority.
I'm sorry, the corporation bank judgment, commercial bank judgment of the
Section 529A and 530 is very clear. The government dues come subsequent to the secured creditors.
That's right. 529A says just that. So
it's a very clear statutory provision, and that is repeated in the new Act.
Let me tell you, there are now many judgments. The sales tax department in various states, in some states, where the enactment has provided them to have priority over the dues of secured creditors, the Supreme Court has also held that the priority is established. There are certain states where they have amended the Sales Tax Act in this way. There are certain states where they have not amended the Sales Tax Act in this way. You are aware that with respect to labor dues, there is a pari passu charge. So the question is not as simplistic.
This is where there is no winding up. You see, in case of winding up, a central law is making a contrary provision, and that will prevail over the state law.
In fact, if I may say so, sir, if there is no winding up under the judgment of the Supreme Court, Canara Bank versus Allahabad Bank, an unsecured creditor can take priority over a secured creditor. So it's a very complex environment in which we are dealing.
My view is that there is no doubt about the fact that the secured creditor is going to be immensely responsible when he takes his decision, because ultimately everybody knows that there are all these different stakeholders.
It's leaving out labor. It's leaving
out.
No,
that's the point, Menaka. You must know that ultimately, as a secured creditor, when I am sitting where I am going to be looking at the entire slew of issues that are going to arise.
Does this put too much power then in the hands of the secured
As a matter of fact,
creditor?
it does, and it brings upon...
Is that the right thing to have done?
No, but if...
To my mind, it has to, because otherwise how do you recover public monies?
To go into winding up, I don't mind that. I'm saying there is inability to debt, go in winding up.
If it doesn't work out, the secured creditor will make an effort to work it out.
Right.
If it doesn't work out, 75% in value have a power to resort to action under SURFACE and take possession of everything and sell it.
So then the final question, is this better than the current provisions that we have, given that Chapter 19 is not yet notified and therefore in force? Is this better than what we had under SICA, BIFR, CLB and all of that?
10 years from now, I guess we will know exactly where we were.
But on the face of it?
For sure.
On paper?
For sure, no question about it.
That? So?
Yeah, it's much better than what it is.
Much better. For everybody involved, all
everybody
stakeholders.
Involved, all stakeholders. And it is going to benefit the corporate sector. And it's...
not just creditors.
Not just creditors.
Okay. Alok, since you've played skeptic all this
yes
time.
and no. There are certain provisions in this which certainly progress the entire concept of rehabilitation and revival.
Like the Committee of Creditors.
Like the Committee of Creditors, insolvency practitioners. And I must again say, the focus on the creditors. Creditors are very, very important in any rehabilitation and restructuring. The only reservation I have is that they are not the only entity which is interested in the process of rehabilitation.
So, well, look, I think eventually when we come back to 253, let's just get back there, because that's really the parent provision under Chapter 19. I think that it vests an immense level of responsibility with the secured creditor, and we have to trust the secured creditor to take a decision in the interests of all concerned. So I somehow
I'm sorry, I really don't see that. I don't see any secured creditor. Every secured creditor has a responsibility to recover his money and the best that he will for himself.
You see, secured creditors are also interested in upgrading an account which is classified as non-performing, which will allow them to write back the provision, which will allow them to charge interest and recover interest on their loans, which otherwise they can't charge if it is in the category of non-performing asset. And if this method is going to result into turning around the company,
why would they abuse
and they start repaying the installments of the loans and all that, why should they not be interested?
All right, I'm going to let that be the last word because we're entirely out of time. Thank you very much to all three of you for joining us, and thank you very much for watching. We do still have winding up to discuss. Stay tuned to the series.
Companies Act, a special presentation by The Firm.